Well, this afternoon, if indeed it's the afternoon for you, we're going to be looking at the litigation process and alternative dispute resolution. I've used the shorthand in the slide dispute resolution, but we're really looking at alternatives to the litigation process when we speak about alternative dispute resolution. Litigation just being one form of dispute resolution, although probably still even today the most predominant one. So what kinds of situations can give rise to what we call civil litigation? Litigation of a civil nature, which is not criminal, but involves a dispute between two private individuals or two businesses or an individual or a business, or even civil disputes between government and businesses over, say, contracts, or where government has been negligent and there's a civil lawsuit against the government. So just as a few examples, let's assume that Jimmy punches Ajmal in the face. And that causes dental work requirements of $10,000. Well, there's a good likelihood that Ajmal will sue Jimmy for the assault because, as we know, assault is a tort. It's a civil wrong, and therefore Ajmal would likely want to sue Jimmy, not only maybe for the $10,000 that the dental work cost him because of the punch, but also maybe for some pain and suffering, and maybe Ajmal lost time off of work and has other expenses that he wants to claim as well. Or another situation that might arise is, let's say Layla, after several days of icy storms, does not put salt on the path to her house, and somebody slips and falls outside of the house because of that and breaks a leg. Well, you might expect Layla to be sued as well because, as the occupant of the property, she has a responsibility to not be negligent and to keep it clear. And certainly waiting several days to throw salt on the ice might constitute the basis for a claim against her, and so the person who fell might want to sue her. Or a doctor amputates the wrong leg. Sounds like medical malpractice, another form of negligence. Seems to me that the person who suffered that wrong might want to sue the doctor for damages. All those are instances of tortious bases for litigation, one of them being an intentional tort, and two being unintentional torts, negligence and occupier's negligence. And finally, just to illustrate the fact that a dispute can arise out of a contract, I give you the example of an owner who does not pay the last installment of $25,000 for renovations to the renovator in accordance with the contract. The renovator may want to sue the homeowner for not paying the balance owed on the contract, and maybe the homeowner has a defense. Maybe the work was shoddy, so that would give rise to, or alleges it was shoddy, so that would give rise to civil litigation as well. And that's what civil litigation is. It's a dispute of a commercial or personal nature between two people, or it could be, as I said, between a business and the government if there's a contract dispute, or let's say a municipality has been negligent in maintaining roads. That could give rise to a litigation between a government entity, in this case the municipality, and an individual. And in all these instances, the courts here are being asked to provide compensation. Note that if you breach a statute enforced by the government and there's a fine associated with it, that is not civil litigation. That is regulatory enforcement, and you are prosecuted by the state. That would include bylaw infractions. It would include provincial laws. It would include federal laws where the state expects you to act in a certain way, and if you don't, you will be fined, like speeding. Here, the courts are basically asked to punish you for your non-compliance with the regulatory obligations imposed upon you by the state. Now, the worst kinds of regulatory offenses imposed on you by the state are the ones that are considered criminal in nature on Canada's criminal code. And again, punishment is one of the key objectives, although rehabilitation may be another objective. But the primary objective is not compensation, which has actually been a basis for criticism of the criminal justice system, because some people feel there should be some consideration given to victims for crimes, and that there should be some element of compensation. There is now a little bit of that in the system, although not very much. And we usually look at victim impact statements as a basis for imposing maybe greater punishment as opposed to providing compensation. But really, the area of compensation is left to civil litigation, even where a tort is also a criminal offense. The criminal courts will go after the person to impose punishment and maybe rehabilitation. But as we said previously in the course, a tort can also be a crime. And so the criminal part gives rise to criminal litigation, and there's a rehabilitation and punishment imposed, whereas compensation is the role of civil litigation to provide where a tort has been committed. And whether it's a tort or this contract dispute that has given rise to the civil litigation, the primary function of the courts here in civil litigation is to provide compensation. Again, there are exceptions. Sometimes there are punitive damages awarded, but not too often in Canada. So criminal litigation is the process pursuant to which regulations and crimes are prosecuted by the state, whereas civil litigation is the process or the set of rules which dictate how a lawsuit where there's somebody suing for damages is governed. So in a civil lawsuit, as opposed to a criminal case, the party suing, the person looking for compensation, is called the plaintiff, not the Crown. Because in a criminal case, it's the Crown or the state that's going after the defendant. In both instances, we're very often referring to a defendant, although in a criminal case, the defendant is also often called the accused. So in a civil case, you've got a plaintiff suing a defendant. In a criminal case, you've got the Crown or the state prosecuting, not suing, prosecuting, and again, possibly a defendant, but also sometimes called an accused. Now, in a civil case, the burden of proof, in other words, the evidence must prove the facts necessary to establish liability at law on a balance of probabilities. And a balance of probability simply means kind of like a 51-49 thing. It's kind of a balancing act, but on balance, the evidence proves the facts to my satisfaction in a civil lawsuit as a judge, where I say that the plaintiff should win, or if it doesn't do that, well, then the defendant should win. If I find that as a judge and the plaintiff is successful, the defendant is found liable. In a criminal case, the party prosecuting, as opposed to suing, is the state or the Crown, and in this instance, the burden of proof is higher than in a civil lawsuit. It must be beyond reasonable doubt. So very little doubt in the mind of a jury or a judge. The fact of the matter is that it's easier to win a civil lawsuit than a criminal prosecution because of the differing standards of proof. In a criminal prosecution, the evidence has to establish the facts, establish the facts that establish the legal liability, in a criminal case beyond reasonable doubt. So evidence has to prove the facts needed to convict beyond reasonable doubt in a criminal case, whereas the evidence establishing liability in a civil case must only establish the facts necessary under the law to successfully sue on a balance of probabilities. Another notable distinction in the terminology is that if you're found guilty in a criminal suit, well, it's a finding of guilt. Whereas if you are found to have been liable to pay the other party in a civil suit for damages, that's considered liability. So suing versus prosecution, plaintiff versus the Crown. In both instances, it is the defendant. Beyond reasonable doubt in criminal case, on a balance of probabilities in civil. And last but not least, in a criminal case, there's a finding of guilt. In a civil case, there's a finding of liability. Now, who makes these determinations? A prosecution, if it's criminal, is brought before the courts. Likewise, a civil lawsuit is also brought before the courts. And these courts are established by the Constitution. Section 9214, and that's not quite accurate. I should say the Constitution allocates jurisdiction as to what level of government can establish courts And that's what the Constitution does. So the Constitution says, for example, under Section 9214, that the provinces have the power to establish and maintain provincial courts with jurisdiction over disputes arising under both federal and provincial laws. So you can, in fact, and very often you usually do, pursue a criminal case in a court established by the province, even though the criminal law is been promulgated or adopted by the federal parliament. Now, there are certain federal courts established as well. Section 101 of the Constitution gives the federal parliament sweeping powers to establish federal courts as well. So on the one hand, you've got superior courts in Ontario, for example, and a small claims court in Ontario, established by the province under Section 9214 of the Constitution to handle, with jurisdiction to handle all kinds of federal and provincial prosecutions, as well as deal with civil lawsuits in the courts. You also have certain courts established by the federal government, the Supreme Court of Canada and the Federal Court of Canada being the two, which have jurisdiction to deal with more uniquely federal things in the case of federal court, such as intellectual property, tax evasion, immigration, whereas the Supreme Court, which is established by the federal government, is also the final court of appeal. So it's a bit of a mishmash, to be honest with you. So typically a case may start, a civil lawsuit may start in Superior Court, which is provincially established. It's rarely going to start in federal court unless they're suing the federal government. Certain unique kinds of cases, maritime law, intellectual property law, can also be started in federal court. A lot of overlapping jurisdiction. So sometimes you have a choice of suing in the provincially established court or federal court. But the bulk of litigation does take place in a superior court of provincial creation, such as the Superior Court of Ontario. You start your lawsuit there. You'll have appeal to another provincially established court called the Ontario Court of Appeal. But then your final appeal is going to be the Supreme Court of Canada, which is established by federal legislation. That's a typical appeal route which you'll find in most civil lawsuits, if it in fact gets appealed. Your trial in Superior Court, your appeal, if it goes to the next level, to the Ontario Court of Appeal, which is also provincially established. And if one party still feels strongly that they have a case, the next level of appeal is to the final appeal in Canada at the Supreme Court of Canada, and that is established by the federal government under a federal act. So that's the usual progress. Now, as I say here, the federal court established by the federal government deals with disputes arising under federal laws only. And this is a statute that was adopted by the federal parliament. These two courts being the Federal Court Act and the Federal Court of Appeal, because there's a Federal Court of Appeal, have jurisdiction across Canada, of course. But as I said, they only deal with certain unique areas of federal law, intellectual property law, tax disputes at the federal level under the Income Tax Act, maritime law, immigration law. There's a certain degree of overlap of these courts with provincially established courts. In addition, each province has established its own court system, and in Ontario, the statute that has established the Ontario courts is called the Courts of Justice Act. So if you look at the provincially created statute called the Courts of Justice Act, which is an Ontario statute, you'll see that it creates the Small Claims Court. It creates the Superior Court. It creates the Ontario Court of Appeal. However, two courts of federal jurisdiction, the Federal Court Trial Division and the Federal Court of Appeal, are established by the federal government, and all of these courts can give rise to appeals, all of which will end up, if they go that far, to the Supreme Court of Canada, which is again created by a federal statute. Now, as I said, in the Ontario courts for civil litigation, there are two key courts. One is called Small Claims Court and one is called Superior Court. There's also a family division of Superior Court as well for family disputes. And as far as civil litigation goes, all these are created by the Courts of Justice Act, as is the family division of Superior Court. And each of these courts, be it Small Claims Court, Superior Court, or Superior Court Family Division, have their own rules of civil procedure, their own processes which guide a dispute through the system until it eventually gets to trial. These rules of civil procedure are adopted by regulation. So under the Courts of Justice Act, which is the statutory regime creating the courts I just talked about, you have various regulations. And one set of these regulations are the civil rules of procedure for civil court, superior court, another for family court, and yet another for small claims court. Now you can, for example, find the link for the small claims court rules on the web. Now I say this, that the link is embedded in the text. That actually applies to another course I teach, not this one. So ignore that comment here. But if you go to, if you Google Ontario courts, you will go to a website which leads you to the rules for each of these courts. And if you Google Ontario court forms, or just look for the court forms under the Ontario courts website, you'll find the forms that are used as well to move the process along. And we'll talk about those very shortly. Now, the book, Looking at Law, says that the jurisdiction of small claims court is $25,000. That was actually increased to $35,000 on January 1st, 2020. It's important to note that small claims court cannot give certain kinds of remedies like injunctions. It pretty much is a court where you can only get damages. And there's something in the textbook called, when they're talking about Superior Court, called the simplified rules. These are less bureaucratic rules and less expensive rules, which the textbook says apply to cases for $100,000 or less. Again, on January 1st, 2020, that level was increased to $200,000. So when you read Looking at Law, bear in mind that these changes have been made since the book was published. And as I say, the simplified rules are simply a simpler set of rules for cases between $35,000 and $200,000. So really, the way the system is conceptualized is that for disputes up to $35,000, we're going to try to keep as little red tape there as possible. You go to small claims court, you probably can get away without having a lawyer there because the rules are less complicated. If your case is over $35,000 and up to $200,000, where then you're in superior court and you have a somewhat more complicated set of rules than you do in small claims court, but they're simplified rules compared to the most complicated set of rules, which are again in the civil rules of procedure for superior court, and they apply to claims of $200,000 or more. So I really got three levels of complexity in the set of rules that you have to consider. So once again, there's a litigation process involved if you're suing somebody, and that's what these civil rules of procedure talk about. We're not talking about the criminal litigation process at all here. We're talking about disputes of a civil nature that usually arise in tort or contract. It's generally one or the other. I can't think of much that's something else, except for family law, of course, which goes to the family division and has its own set of rules. So in order to sue somebody who you think owes you money, let's say you loaned them money and they didn't pay you back, or you had a contract with them like that renovator, or if there was a tort committed and you were the victim of that tort, like Ajmal, who was punched by Jimmy, or like the poor person who had the wrong leg amputated, and you feel you should get compensation, well, the way you do that is you can sue, usually hiring a lawyer to do this by drafting a statement of claim. A statement of claim is what it's called if you're in superior court. We just call it a plaintiff's claim in small claims court. And you can see those forms, once again, if you want to go to Ontario Court Forms and see what they look like on the web. So basically what a person does when they want to sue is they fill in the form and they say, I'm something like this. I'm claiming X dollars because of what this person did to me. That's pretty much it in a nutshell. The story is laid out very elegantly in numbered paragraphs. But basically what it's all about is saying, I'm suing for this amount of money. Here are the facts that I'm alleging happened that justify me getting this money. Here's the references to the law that entitle me to this money based on the facts. This is my claim. That's why you owe me money. The next step is called the statement of defense, where the person who's being sued says, no, that's not what happened. Or no, maybe that's what happened, but the law is not as the person states, or some combination of that, and that basically is what the defense is. Then the next step in the process is where the parties exchange something called affidavit of documents, and we'll look at this in more depth very shortly. This is just an overview. And basically each person there has to swear on a piece of paper called an affidavit, which is perjury if you're lying, and it's sworn in front of a lawyer or other commissioner of oaths, where you swear these are all of the relevant documents that, or other evidence, like videotapes or what have you, that form part of my case, that are my evidence, and I'm giving them to you in advance, and both parties have to do that. Every once in a while, some complicated things comes up in the middle of the case at any kind, which should not be left for trial, something that comes up that needs to be resolved by a judge as part of the process, and this is dealt with by something called motions. I wouldn't worry about those too much, just so that you know what they are. And then there's something called examinations for discovery. Sometimes you can have motions after examinations for discovery, by the way. And an examination for discovery is where each party has a right to examine the other party to probe for the strength of its case, and then you eventually go to trial if it doesn't settle by then. So I guess let's start back to square one, and you are a person who wants to sue somebody. Before you sue and before you fill out a statement of claim, you need to figure out where you should sue the person, in what court. Sometimes, let's say you live in Ontario and the defendant lives in Alberta. Well, you may not want to sue in Ontario. You may want to sue in Alberta in their courts applying their rules of civil procedure, because if the defendant lives in Alberta or has assets there and does not voluntarily pay the judgment, you want to get a judgment in the jurisdiction where there are assets, so the court can enforce the judgment for you if you take necessary steps and collect the judgment. Or if the defendant works in Alberta, you may want to garnish his wages in Alberta. So very often you want to make sure you're suing in the right place, as long as there's jurisdiction, because there has to be jurisdiction there as well. Usually if the defendant lives in a province, that's sufficient to say that the court has jurisdiction. So if the court has jurisdiction in a matter, which it usually does when the person lives there, you may want to sue there as opposed to Ontario. So step number one is, okay, what province do I want to sue in, or even what country? If the person lives in Bangladesh, maybe you need to sue in Bangladesh. And you need to figure out the jurisdictional issue. Do you have jurisdiction? Does the matter give you jurisdiction to sue in Bangladesh, or do you have to sue in Ontario? And if the person has no assets in Ontario, then try to get the Bangladesh courts to enforce it. So very difficult decision sometimes. If both parties live in Ottawa, then it makes it easy. You're going to sue in an Ontario court and in an Ottawa court, because then you even have to pick not only the province, but the county or the court area where you want to sue in, because there's a court in Ottawa, there's a court in Toronto, there's a court in Oshawa, there's a court in Timmins. So not only do you have to choose the right province and the right country, but sometimes even the right city or county to sue in. And you may want to consult a lawyer about that. But once you got that all figured out, then you pick that jurisdiction, and that's the jurisdiction where you fill out the form. You do it online, so if it would be Ottawa Small Claims Court, or you'd pick 161 Elgin Street in Ottawa if you're suing in Ottawa, it's easy if both parties live in Ottawa. So you may want to think about that before you choose what jurisdiction you're suing in. If you choose to sue in Ontario, then you have to figure out not only the right place of the court, but also the right amount. So if it's $50,000, I'm not going to sue in small claims court, but I still have to figure out if it's going to be in Oshawa or what have you. If it's under $35,000 or $35,000, you can say, okay, I know I'm small claims court, but I still have to figure out if I'm going to sue in Oshawa or Toronto or Ottawa or Timmins or what have you. So a lot of decisions to be made when you're picking your jurisdiction, the court that has jurisdiction. Once you do that and you're defending in small claims court, the process is less complicated. So you start with something called the plaintiff's claim. You fill it in. The defendant fills in a statement of defense. Those are both filed with the court. You can do it online now. Increasingly, everything's going online since the pandemic. Usually a notice of settlement conference occurs after that, where the parties get to sit in front of a judge, and the judge tries to mediate, really. We're going to talk about mediation a little bit later, but this judge tries to mediate, which is a little bit confusing because the article later on talks about the distinction between a judge and a mediator. But in this instance, where there's a settlement conference, the judge actually acts as a mediator. And if he gets the parties to settle, great. If he doesn't, it goes to trial, and then it has to be another judge who will actually act as a true judge and deal with the trial that comes. If you're in small claims court, you're also supposed to exchange documents and a witness list on this form called Form 13A. You're supposed to do that before the settlement conference. Once again, these are being held virtually more and more. If there's no settlement, the judge provides a timeline for completion of any of the next steps, might be expert reports or other evidence, and then it's set down for trial, and a completely new judge has to hear it as a judge and not as a mediator. Now, if you're going in superior court, well, it's a little bit more complicated. First of all, the initiating document is not called the plaintiff's claim, but called a statement of claim. And you generally describe the remedy sought. What are you looking for? What do you want the court to give you? Do you want the court to give you an award of damages, plus your legal costs, plus interest on it? Or do you want the court to give you some other remedy, an injunction, which is an order stopping from somebody from doing something, or an order such as specific performance, requiring them to perform a contract? So in paragraph 1, you usually describe what the remedies are that you want. And then you describe the facts that underpin your claim. Like in the case of Ajmal punching Jimmy would say in a statement of claim, on or approximately at 3 o'clock on September 5th, 2018, the defendant Ajmal punched me in the nose at the corner of Spark Street and Bank Street because he told me he didn't like me. 2, the punch was extremely painful, caused me to go to the dentist, which cost me $10,000. 3, I also had to see a psychiatrist, which cost me $3,000. 4, I've been very depressed. Basically, you lay all this out. So those are the facts. Now, the evidence that's going to be needed at trial or later on to prove those facts is going to be the eyewitness testimony of anybody else who saw it, including Jimmy, of course. The dentist's bill. Maybe the dentist will have to be called as a witness explaining what he or she did to the mouth. Then the psychologist's report, which would be an expert report saying that the fellow was very depressed after he got hit. That would be more evidence used to establish or prove the facts on a balance of probabilities that these things happen. And if these things all happened and are proven as having happened on a balance of probabilities, then Jimmy would go on at trial to argue the law that under the law of torts and under the specific intentional tort of assault, he's entitled to those damages. But that's getting ahead of the game. In the actual statement of claim, all Jimmy describes is the alleged facts and the law on which he is relying to establish the damages, plus describing the damages and describing how much money he's after. Once you've written all this down in the court form provided, which is available online, it used to be that you would attend court to get it issued by the court, but now you can do this online as well. And basically, you pay your money, whatever the fee is at a given time. They give it a court file, and they give it a stamp. They spit it out, and then you must serve it, which means give it generally in person to the other person. When you give it in person to the other person, you swear an affidavit, a sworn document, which says that you or a process server, usually a good idea to get a process server to do it, so there's no doubt that it happened, swears under oath that they gave the document to somebody on such and such a date at such and such a time. And you file that copy of the claim with the affidavit of service at court, either online now or in person. After you do that, if the person being sued is smart, they will file a statement of defense as a defendant. If they don't, then you can move, and here's one of those motions we talked about, for default judgment. So first you note the party in default, and then unless it's what's called a claim for liquidated damages. You might have to have a motion to prove exactly how much you think you should get. I won't bother you with the details there. The bottom line is, if somebody doesn't file a statement of defense, it's as though you're in a baseball tournament and one of the teams doesn't show up. In that case, the team that showed up wins by default. And that's what basically happens if you don't defend. You'll get a default judgment against you, one way or another. So to avoid that, to show up as your team in a baseball tournament, you file a statement of defense and you send it to the plaintiff. Under the rules of Superior Court, if you're served in Ontario, you have 20 days to file your statement of defense. You can gain an extra 10 days by filing what's called a notice of intent to defend. And of course, the statement of defense will just describe your side of the story, the factual and legal reasons why you think you're not liable. Sometimes more than one defendant is sued. Sometimes several people are blamed for something that happened. So the plaintiff could sue 2, 3, or 4 people. And if that happens, a defendant who feels he or she is not to blame, but the other defendant is, or several other defendants can also file a cross-claim against the other defendant. And every once in a while, a defendant may believe that, well, it's not my fault. It's really this other person, this third party who caused everything, therefore I'm going to third party them. So a cross-claim is when somebody already named in the lawsuit is somebody you think should bear the burden of the entire loss, or even part of it, in which case you cross-claim against them. But if it's somebody who hasn't been named in the litigation, then you can start a third-party claim against them. So let's say A sues B and C, so there are 2 defendants, B and C, and only one plaintiff, A. But B really believes that C is entirely at fault and therefore has a claim of his own against C even. Well then, the question is, in Superior Court, this claim would it be called a third-party claim or a cross-claim? Well, you probably have guessed that it is a cross-claim because it's a claim against one defendant by another defendant. If there would be a D who hadn't been named in the litigation, then you want to issue a third-party claim against D in that instance. So once these documents, they're called pleadings, by the way, the statement of claim and statement of defense are called pleadings because everybody pleads their case in it. Once they're exchanged and filed in court, after a period of time set by the rules, the parties are supposed to exchange an affidavit of documents, as I said. And that's a sworn statement where you list every relevant document. You have an obligation to do that. If you don't do that, if it helps you, you might not be allowed to introduce it later on. And if you don't, there are other penalties that can be applied. And not only are you supposed to exchange the affidavits, but ultimately all of the documents named in the affidavits must be exchanged. That's called production of documents. And that includes everything that's relevant. It could be emails, it could be texts, digitally stored data, real paper, of course, videotapes, recordings, sound recordings, any kind of preserved data which is relevant to the case is evidence that can be used in the case and therefore must be produced before the case. The idea here is that nobody is surprised by evidence or productions that they didn't see before the examinations for discovery and certainly before the trial. Once all that stuff has been exchanged, we won't bother with the interim motions, we talked about that. Once all that stuff has been exchanged, then you can have what's called the examination for discovery, called depositions in the United States, where one party can ask all the questions it wants of the other party about the case. And the idea there is to find out all the arguments the other party has. So part of it is just exploratory, to discover what the other party has to say. So part of it is to see how strong the case is, the merits of the other side's case. Another part of it, though, is also to try to get admissions that will hurt the other party's case. Now, this examination for discovery, and each party has a chance to do it to the other party, is conducted before, it used to be always before the special examiners, they were called. Now there are other court transcription services that will do this, and they make a transcript of the whole thing. And so there's a transcript available which can be used by the party conducting the examination at trial. Eventually the thing gets set down for trial, and there is a trial. Now the trial is adversarial in nature. It means that it's like a competition. One party is against the other. So this competition is really governed by the process in the rules of civil procedure, where the plaintiff first calls a witness, because the plaintiff has to prove the case, and the witness introduces evidence through oral testimony. Could be, documentary or other evidence too, such as did you sign this document, that kind of thing. And this is proven to the satisfaction of the judge. The facts are proven through this evidence. Now, once the plaintiff has finished the examination in chief, as it's called, of its witness, the other side can cross-examine. And the idea of cross-examination is to damage the credibility or show that the other person's recollection isn't correct, or to try to get them to contradict things that they've already said, or make admissions of facts that weren't said during the examination in chief that may actually help your case. And as somebody who's cross-examining another party, you have the right to ask leading questions. What's a leading question? Well, a leading question is, you were pretty drunk when you did that, weren't you? That is a leading question because it suggests the answer to the person. The person conducting an examination in chief is not allowed to ask leading questions. These are rules of evidence and procedure, by the way. Whereas a person cross-examining is allowed to ask leading objections. So if a plaintiff asks his witness, you weren't drunk at all on April 8th, 2020, were you? The other party should object and say, objection, Your Honor, that is a leading question, and the judge will agree with you and ask the person to rephrase the question possibly. A proper question would be, what was your state of mind on April 20th, 2020? Not were you were not drunk, because it has to be an open-ended question that can't suggest the answer. And another advantage of cross-examination is you get to use the discovery transcript against the person testifying if they were the one who was on being discovered. So that's why it's important for a witness who's preparing for trial to know what they said during their discovery. If you say something different, that's going to be used to attack you. If improper questions are raised, like a leading question on examination in chief, or hearsay evidence where the fact that you heard somebody say something doesn't mean that the something actually happened, well, the party who's listening to the first person getting the examination done can object. Anyway, let's try seeing if some of this quick lesson in evidence has sunk in at any level. And the bottom line here is that Jennifer, well, I guess I should read it. Basically, Jimmy asks his witness, Jennifer, what she saw at the time of an accident. And she says that she did not see what happened, but her boyfriend, Jake, was standing right there. And he said, this is what happened. Well, that clearly is not allowed because that's hearsay evidence. So will the judge accept the objection? Yes, because Jennifer is only repeating what Jake told her, and therefore that's hearsay evidence and is inadmissible, and the objection would be well-founded. Of course, what the person should do is call Jake to the stand, because Jake actually saw the incident and his testimony would be allowed, but not hers. So let's say you go through all of that, you win your case, the judge says, yep, I believe your damages should be $80,000 based on the evidence you told me, you win, the defendant is liable. Not only that, but you had a lawyer help you and I'm giving you extra costs of $5,000. Let's assume the defendant does not appeal. Because if he appeals, of course, then there could be an appeal and you might lose on appeal. But that doesn't happen. Well, if the person doesn't pay the judgment voluntarily, you have to use the enforcement tools available to you through the court system. One of them is called a writ of seizure of sale, not called a writ of execution, which is filed against lands and assets of the judgment debtor, in other words, the defendant who lost. And after periods of time, those lands can be seized and those assets can be seized under a writ of seizure and sale and sold to satisfy the judgment. Or something else you can do to enforce a judgment is get a court order based on the judgment to garnish the judgment debtors or the losing defendant's wages if he's got a job. That gets served on the employer. The employer is obliged to allocate 20% of salary, unless it's a family law award of child support or alimony, in which case it goes up to 50%. 20% of wages can be garnished every 2 weeks, or whatever the pay is, until the payment is, the judgment is satisfied. Plus, garnishment can also be used on bank accounts because a bank account is nothing more than a debt owing. If, as the plaintiff, you don't know what the party owns, you can do a judgment debtor examination where the person, once a year, where the person has to show up and answer your questions and disclose all the assets he or she owns, where they work and everything, which gives you the information necessary you need to either issue a writ of seizure or sale or garnish to get your judgment paid. The bad news is, as an unsecured creditor, you have to share anything you can collect with all the other unsecured creditors pro rata. So let's say you collect $1, you were owed $100, the other person was owed $300, well, you would get 1/4 of that dollar collected. So here's a bit of a complicated question, which is just laid out for you so you can understand the process a little bit better. Basically, in this situation, Jerry gets a judgment of $8,000 against Lucinda. Jerry has Lucinda's card sold by the sheriff. So what has happened here is that Jerry got a writ of seizure and sale issued. That empowers him to instruct the sheriff to seize the car under a writ of seizure and sale. The sheriff's costs are $1,000 and Lucinda owed $10,000 on the car to the Bank of Nova Scotia, who financed it when she bought it. BNS has a Personal Property Security Act lien on the car. How will the proceeds be distributed? So this is interesting. Jerry has a judgment of $8,000, but he's an unsecured creditor. The car is sold for $16,000. So there seems to be an extra $8,000 floating around, and there's $1,000 that's added onto the costs that have to be taken off the top of the cost of the car because the sheriff always has to get paid. So Lucinda owed $10,000 on the car, which is liened. So basically, Bank of Nova Scotia is a security interest in the car. So what's going to happen is the sheriff will receive $1,000 and the bank and Jerry will split the balance in proportion to the sum each is owed? The answer is no. The sheriff will receive $1,000, but the bank and Jerry will not split it in proportion to the sum owed because the Bank of Nova Scotia is a secured creditor for the full $10,000. The second option is the sheriff will receive $1,000, yes, and Jerry will get $8,000 and the bank $7,000 because the bank does not have a judgment against Lucinda. No, because the bank is a secured creditor with a PPSA lien. What's going to happen is C, the sheriff will receive $1,000, the bank will receive the $10,000 as the full amount being a secured creditor, and the excess value in the car goes to Jerry, $5,000. So Jerry will get $5,000 out of his $8,000 judgment in this. So as you can see, it's not that easy to necessarily enforce a judgment. And when we go back to the case of Becker versus Peckus, which we talked about during the family law lecture, you'll recall that they were running a beekeeping business. They were living common law for 19 years. All the assets were registered in the husband's name, and the Supreme Court of Canada upheld the Ontario Court of Appeal decision awarding the common law wife 50% of the assets, and the judgment was estimated to be $150,000. But what happened, as you may recall, is that although Rosa essentially lost the trial and won later on, the defendant, Lothar, did not cooperate. He had his motives. He believed that Rosa had lied, that the court got it wrong. He had married somebody else. But so he didn't cooperate. And so, notwithstanding writs of seizure and sale and garnishments and everything, it took 6 years to sell the business. And then after all that, all the money went to Rosa's lawyer because the legal costs associated with doing all that exceeded the value of what was collected. A horrendous outcome, and she committed suicide. So you can see that getting a judgment isn't necessarily a guarantee that you'll get paid. And moreover, you'll see that the enforcement processes can be frustrated sometimes. So there are dispute resolution enforcement challenges. That's where the money went, and she committed suicide, as you know, which was talked about a lecture or two ago. So some have suggested that maybe court isn't the best way to go, and we saw this in the family law section as well. Where alternative dispute resolution ideas have been used increasingly in family law, collaborative law, mediation, that kind of thing, and the exactly same type of thing has been occurring with civil litigation. So increasingly, people have looked to alternative ways of resolving disputes that are outside the court system. Of course, there's face-to-face negotiations where both parties try to negotiate a compromise to settle the dispute. Then there is something called mediation, which is similar to negotiations, but a trained mediator acts as an independent, neutral, unbiased facilitator to help the parties achieve negotiated settlement. Now, the mediator cannot give a binding decision, but a mediator cannot give a binding decision, but a judge can. And so too can an arbitrator, which is a third kind of alternative dispute resolution, where you appoint a private judge, basically. The parties agree to it, somebody who's not part of the formal court system, outside of it, and that arbitrator really is a kind of private judge, which the two parties hire, split the cost. And the arbitrator, although is agreed upon by the parties, really has the same powers to give a judgment in an adversarial process, which is ultimately enforceable by the courts if you have to collect on it. So now we turn to the introduction book, where there's an article on the mediator and the judge. As I said, in other words, and as the textbook, or I guess it's called the casebook, says, mediation consists of influencing the parties to come to agreement by appealing to their own interest. In order for it to work, the mediator must be perceived as impartial for any chance of success. If one party thinks there's a bias there, it won't work. And also, it will generally not work if one party is unwilling to settle. So some have suggested that mediation might have worked in the case of Becker versus Petkus, if the two had been made to see that it would be in their mutual interest to settle and not have all the money go to lawyers. Nobody can say for sure. Maybe yes, maybe no. Petkus was set in his ways. He believed he shouldn't pay her anything. He was not exactly a feminist. It was very traditional. He thought, well, common law means I shouldn't have to pay anything. So he was very headstrong. It's unlikely that mediation would have worked, but you never know. Maybe if he had been told at one point, look, the law is changing. You're going to pay something. You might as well try and pay her and not waste all your money on lawyers. Who knows? Maybe it would have worked. We'll never know for sure. And then the article gets a little, I should say, wordy and difficult to understand, and talks about norms playing a role in the likelihood of the mediation process working. And basically what they're saying there is what you believe to be right or wrong, in other words, what you believe to be just, may influence whether the mediator will be successful in bringing the two of you in a dispute to a mediated settlement. Now, on the one hand, if the mediator is able to show the parties that, this is what should be done, it's what's fair, well, the norms may actually work in favor of getting a settlement. But sometimes people are really locked into their views of what's just. They have their own idea of what is right or wrong, and they may be so locked into their perspective and ideologically motivated that they're just not going to budge, so norms or their sense of right or wrong might actually get in the way of mediation working. So that's what the book is basically talking about there in rather esoteric terms. And then the article goes on to talk about the role of the judge being completely different. And when we say judge, we also mean arbitrator, which is true. The judge is there not trying to get the parties to reconcile, to compromise. And as the word compromise suggests, it means not being rigidly ideological, but to say, look, put your ideas of right or wrong aside, just use your common sense. Would you rather split $100,000 each, or one of you try to keep it all and then spend $80,000 on legal fees. That's a typical argument used. So that's appealing to each party's self-interest to try to get them to come to a mediated settlement. But the bottom line is the driving force there is reconciliation, whereas in a arbitration or a civil court dispute, it's an adversarial process where the parties are battling it out, not reconciling. And the judge there forcibly applies the norms, or what the law says is right is wrong, or based on the proven facts and the legal rules. And in Becker versus Petkus, the norms that were applied by the Supreme Court of Canada and the Ontario Court of Appeal were norms that were new norms that were changing old morality, where it used to be thought that common law people lived in sin, therefore nobody should get anything unless they actually own it. Well, really, society's morality was changing, so the judge forcibly applied new norms there in the form of recognizing that a common law union is a form of partnership, and if one person works hard or contributes, just because he or she doesn't own it, doesn't mean they shouldn't get some piece of the pie, because the other party would be unjustly enriched if that were to be permitted. So that is new norms being enforced by the judge in that Becker versus Petkus case. Now, sometimes the judge will have seemed to the loser to have lacked impartiality, or sometimes the norms will not be accepted by the judge, as in Becker versus Petkus, where Becker said, yeah, I don't believe any of that stuff. First of all, the judges weren't impartial. They overstated what Rosa did, and therefore rules were unfair to me. They were all, driven by their feminist agenda, is what he would argue. So they were not fair to me. The facts were not assessed fairly. And moreover, I don't even like the norms they applied. Therefore, I'm not paying the judgment. So that's basically what the textbook is saying. Not the textbook, the introductory book is saying. The case book is saying, the Introduction to Legal Studies book is saying that when the judge is perceived to be not impartial, or when the norms imposed by the judge are antithetical to what the loser believes, that person will not voluntarily comply, and enforcement can be problematic. Well, I hope you found this both helpful and interesting, and I thank you for your time. Take care.